Exam Scholar, Real Estate Edition.
Question 1. Which of the following is not a way in which mortgages and trust deeds differ? A. Securities. B. Title. C. Statute of limitations. D. Parties. Answer. A. They are both security interests in property. They provide the legal right to have the property sold in the event that the borrower defaults. Question 2. The statutory dedication process is completed when A. The appointed representative of the city or county signs accepting the dedication. B. The final subdivision map is recorded. C. The dedicated area is completed. D. Local authorities deliver a signed acceptance to the subdivider. Answer. B. Upon the final subdivision may being recorded. If the subdivider has dedicated an area through a dedication certificate and the dedication has been accepted by the properly authorized official, then the recording of the approved map would be the final step in the statutory dedication process. Question 3. When duly recorded in the county where the property of the judgment debtor is located, an abstract of judgment for money awarded by a court becomes A. An involuntary lien. B. A voluntary lien. C. An attachment lien. D. An equitable lien. Answer. A. A lien is a money encumbrance. In this instance, the encumbrance is placed on the property without the owner's consent and is, therefore, involuntary. Question 4. At 12 o'clock noon, Baker made an offer to purchase a single-family residence. He instructed his real estate broker not to present his offer until 6 p.m. By 6 p.m., 3 more offers had been submitted. The real estate broker should A. Ignore the other offers. B. Present all offers to the property owner in the order they were submitted. C. Present all offers to the property owner simultaneously as soon as possible. D. Wait until the seller acts on the first offer before presenting the other offers. Answer. C. The rule of agency is that all offers must be presented to the seller and let the seller make the decision as to which offer to accept. Question 5. One side of a section equals how many feet? A. 43,560. B. 5,280. C. 2,640. D. 1,000. Answer. B. A section is 1 mile on each side. 1 mile equals 5,280 feet. Question 6. Which of the following is required in a valid homestead? A. Statement that claimant is residing on the premises and desires to claim it as a homestead. B. Statement giving the exact cost of the homestead at time of purchase. C. A description of the property including a description of the improvements. D. Signature of both husband and wife. Answer. A. Any person filing a homestead is required to reside on the premises at the time that he records the homestead and to sign a statement that he desires to claim it as a homestead. The person claiming a homestead does not have to give the cost, or a description of the improvements on the property, and it can be filed by either a husband or a wife. Question 7. The broker, as agent of the seller, owes the buyer A. Only a duty to disclose any item which relates directly to the sales price of the property. B. The same fiduciary obligations he owes to the seller. C. Only the duty to answer questions honestly. D. The duty of honestly and fair dealing. Answer. D. This deals with the responsibility an agent owes the buyer when the licensee is the agent of the seller. He owes the seller fiduciary obligations, the buyer, the duty of honestly and fair dealing. Question 8. Harry owns a building in a commercial area of town. Tina rents space in the building and operates a bookstore. In Tina's bookstore, she has installed large reading tables fastened to the walls and bookshelves that create aisles from the front of the store to the back. These shelves are bolted to both the ceiling and the floor. Which of the following best characterizes the contents of Tina's bookstore? A. The shelves and tables are trade fixtures and will convey when Harry sells the building. B. The shelves and tables are trade fixtures and may properly be removed by Tina before her lease expires. C. Beck. As Tina is a tenant, the shelves and tables are fixtures and may not be removed except with Harry's permission. D. Because the shelves and tables are attached to the building, they are treated the same as other fixtures. Answer B. Common law protects business tenants who install fixtures for their business by treating these trade fixtures as their personal property and giving tenants the right to remove them before the end of their lease. Any damage to the building due to removal is to be repaired by the departing tenant. A licensee who participates in the sale of business property should make known to purchasers what, if any, trade fixtures there are that will not convey with the building. Question 9. A real estate license is A. Constitutionally protected right of the individual. B. Privilege granted by the state. C. Right granted by the Office of the Attorney General. D. None of the above. Answer B. Like a driver's license, it is a privilege. Question 10. If, in a transaction, the amount made as a deposit is not sufficient to cover the monetary damages incurred by a party to the real estate sales transaction, the following party could not file an action in a court of law. A. The buyer. B. The seller. C. A real estate broker acting as an agent for his principal. D. An attorney action for his principal. Answer C. A real estate broker acting as an agent for his principal is a special agent. The broker's powers are limited to acting in the sale of the property. He has no power to file a court action for his principal. Question 1. Which of the following cannot be defined as escrow monies? A. Promissory notes. B. Security deposits. C. Personal bonds. D. Earnest money. Answer C. Personal bonds cannot be used as escrow money because the escrow money must be immediately available in most cases. Any of the other answers listed are acceptable for escrow monies. Question 2. Which of these are considered a protected class under the Fair Housing Amendments Act of 1988? A. A dog. B. A child. C. An immigrant. D. A single mother. Answer B. Of the listed choices, the presence of children in a family were added to the Fair Housing Amendments Act of 1988. Question 3. Ben, the landlord, wishes to charge Betty extra rent because she has a child living with her. This would be considered A. Legal. B. Illegal. C. Legal in certain neighborhoods. D. None of these. Answer B. This practice is illegal according to the Fair Housing Amendments Act of 1988 that included the presence of children in a family as a protected class. Question 4. Building heights, setbacks, and density are usually established by A. Local building inspectors. B. Zoning regulations. C. County ordinances. D. State general plans. Answer B. Zoning regulations control the use of land as well as determine building heights, setbacks, and density. Question 5. What does the Real Estate Settlements Procedures Act cover? A. Residential mortgage loans. B. 1 to 4 family mortgage loans. C. Commercial mortgage loans. D. Installment mortgages. Answer B. Also known as RESPA, the Real Estate Settlements Procedures Act covers 1 to 4 family mortgage loans, including equity loans. Question 6. Careful zoning can have which effect on property values? A. No change in property value. B. Increased property value. C. Decrease in property value. D. None of these. Answer B. Proper and careful zoning can increase property values by means of the principle of conformity. Question 7. If Jerry sold his land to Margaret, he could inhibit Margaret's future enjoyment of the property by what means? A. Nothing. Once the property is sold, it belongs to Margaret to do as she pleases. B. Through zoning laws. C. Through deed restrictions. D. Through court order. Answer C. Deed restrictions are restrictive covenants on the use of the property that run with the land. Question 8. Abel has the right to cross through Peter's property to get to his property. What is this right called? A. A license. B. An appurtenant easement. C. A habendum clause. D. A contract. Answer B. Abel has an appurtenant easement that allows him to cross over Peter's property to get to his own. Question 9. If Nancy owns the property that Heather crosses over to get to her own property, Nancy owns which parcel? A. Dominant. B. Neutral. C. Subservient. D. Servient. Answer A. Because Nancy owns the land that Heather has to cross over by easement to get to her property, Nancy is said to have the dominant parcel. Question 10. In order to bind a contract between two parties, consideration must be A. Money. B. Goods or services. C. Money, goods, or services. D. Anything the parties agree upon is valuable enough. Answer D. Consideration in a contract can be anything agreed upon between two parties that they consider to be valuable enough to satisfy the contract. Question 1. When there is more than one borrower on a note, the obligation to pay the balance is the responsibility A. Jointly. B. Severally. C. Jointly and severally. D. Individually. Answer C. All of the borrowers on a note are obligated and responsible to pay the loan amount both jointly and severally. Severally means individually. Question 2. If a potential buyer sees a home that he or she likes but decides not to buy it because it seems overpriced, this would likely be based on the principle of A. Price. B. Conformity. C. Substitution. D. Habendum. Answer C. The principle of substitution is the idea that there is an equally desirable property at a much lower price. In this case, the buyer is exemplifying this principle. Question 3. What happens when an agent/broker misrepresents the principle? A. Rescission or civil court action. B. Criminal penalties. C. Apologies but no legal action. D. None of these. Answer A. If an agent/broker misrepresents the principal in the sale, there should be a rescission or civil court action for damages. Question 4. If a buyer assumes an existing loan, the buyer also accepts what on the loan? A. Risk. B. Liability. C. Performance of contract. D. Insurance. Answer: B. In this case, if a buyer assumes an existing loan, the buyer also accepts liability on that loan. Of the given choices, this is most correct. Question 5. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as A. Endorsee. B. Endorser. C. Holder in due course. D. Truster. Answer: C. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 6. Most trust deeds contain several clauses of A. Indeterminacy. B. Acceleration. C. Habendum. D. Due process. Answer: B. Acceleration means that if a buyer cannot make payments on a note, the lender has the right to declare the entire sum due and payable immediately. Most trust deeds contain several clauses related to acceleration. Question 7. The surface of the earth and the material beneath the surface of the earth is part of the A. Real property. B. Water rights. C. Section. D. Geolocation. Answer: A. Parts of real property include the surface of the earth and the material beneath the surface of the earth. Question 8. Airways above a property are A. Public domain. B. Owned by the property owner. C. Owned by the owner up to 500 feet. D. Owned by the owner up to 1,000 feet. Answer: A. Airways above property are now considered to be public domain. Use is granted to an owner to a reasonable height. Question 9. If a buyer defaults on a loan and the lender declares the note to become due and payable immediately, this would best be described as A. An exculpatory clause. B. An habendum clause. C. An acceleration clause. D. An momentum clause. Answer: C. This is a classic example of an acceleration clause. Question 10. If demand remains constant while supply increases, which is most likely to happen in regards to prices? A. They will increase. B. They will remain the same. C. They will decrease. D. None of these. Answer: C. Typically, when demand remains constant but supply increases, competition will increase and competitors will lower prices to outbid one another. Question 1. If Steve J. Carlisle offers to purchase a house from the Jeffersons for $723,000 and a closing scheduled for August 7, and the Jeffersons sign a written acceptance with a provision that closing be executed on August 8, what can happen at this point now? A. Steve can back out of purchasing the house without a penalty. B. Steve can hold the Jeffersons to an August 7 closing. C. Steve can sue for specific performance on August 8. D. None of these. Answer: A. Since the Jeffersons made a counteroffer, it constitutes a rejection of the original offer. Therefore, Steve can either accept the new offer or reject it without penalty. Question 2. An agent knows a person that wishes to sell their existing property to purchase another more expensive property listed through another brokerage. What is the agency relationship to all parties involved? A. The known person is the agent's customer. No relationship exists between the seller of the more expensive property. B. The seller of the more expensive property is the client. The agent is in dual agency with both clients. C. The agent's known person is the client. The seller of the more expensive property is the customer. D. The agent is a dual agent to all parties. Answer: C. Under the laws of agency, in this particular situation, the known person is the client, and the seller of the other property is the customer of the agent. All parties are entitled to fair treatment. Question 3. Jeremy is a salesperson at a local real estate firm. He is required to submit to a dress code, attend meetings, and perform marketing tasks for the firm. He is paid in bi-weekly paychecks that have federal, state, and local taxes withheld. In this type of situation, the relationship with the firm is most likely that of A. An independent contractor. B. An employee. C. A contractor for hire. D. A manager. Answer: B. This type of situation that requires a person to perform tasks in a specific way for an organization is typical of an employer-employee relationship. Therefore, Jeremy is most likely an employee of the firm. Question 4. A violation of the Sherman Antitrust Act could be: A. Competing brokers discussing fees and business practices. B. A broker discussing fees with an agent. C. An agent buying stock in the firm they are under contract with. D. None of these. Answer: A. Any discussion between competitors could be seen as an attempt to conspire to set the cost of real estate brokerage services, which is in violation of the Sherman Antitrust Act. Question 5. What happens if the principal is incapacitated or suffers death according to the laws of agency? A. Any contracts in place are cancelled. B. All dates are extended to allow time for processing. C. The agency is terminated. D. None of these. Answer: C. Upon death or incapacitation of a principal, the agency is terminated by operation of law. Question 6. What does a planned development consist of? A. Lots owned in common. B. Individual lots. C. Both individual lots and lots owned in common. D. None of these. Answer: C. A planned development includes both lots owned in common and lots owned individually. Question 7. If a home is located in an area that is zoned for commercial use, the home will have minimum value because of what principle? A. The principle of diminished returns. B. The principle of nonconformity. C. The principle of conformity. D. The principle of delegated zoning. Answer: C. The principle of conformity states that for a property to retain value, it should be in an area that consists of like-type properties. Question 8. If a tenant in a commercial building pays a rental fee that includes all property maintenance charges, utilities, and cleaning services, this type of lease is called A. Performance lease. B. Net lease. C. Pro rata lease. D. Gross lease. Answer: B. A net lease is one that includes rent and operating expenses in the rental price. Question 9. In appraising unique properties, which approach is best for determining value? A. B. Cost. C. Gross. D. Comparative. Answer. B. The cost approach is the preferred method when appraising unique properties. Question 10. Of the properties listed, which is considered the most unique and would use the cost approach method of appraisal? A. A piece of land. B. A condominium. C. A historic building. D. A farm. Answer. C. Of the answers given, a historical building is the most unique type of building and would therefore use the preferred appraisal method of the cost approach. Question 1. Which of the following items is usually considered to be a cost of home ownership? A. Land depreciation. B. Improvement appreciation. C. Amenity value. D. Interest lost on the owner's equity. Answer. D. The interest that is lost on owner's equity is usually identified as lock-in equity. This term applies to the fact that the owner cannot utilize the funds for other investment purposes. Question 2. Abel submitted an offer to purchase Blackacre. During the escrow period, a local credit reporting agency submitted detrimental information which Abel contested. Abel made repeated attempts to get the matter corrected and he was denied access to the information reported to the agency. Abel may A. Bring an action to recover punitive damages of no more than $5,000. B. Bring an action in a court of appropriate jurisdiction to recover actual damages. C. After a prescribed time, require the reporting agency to delete such information from the report. D. All of the above. Answer. D. All choices are open to the principal in question. Question 3. Mr. O'Reilly paid an owner $10 for an option containing this clause, option to be for 60 days from June 1, 1967. Upon exercise of option, holder is to purchase within 30 days thereafter for all cash consideration. On July 10, Mr. O'Reilly sold and assigned his option for $1,000. On July 28, the new holder notified the owner that he would purchase on August 15. The owner claimed the option was void. The option was A. Void, because the holder sold it. B. Void, because date of purchase was not within the option period. C. Valid, even though Mr. O'Reilly sold it, but August 15 was too late for date of sale. D. Valid, and a signee could purchase on August 15. Answer. D. Inasmuch as the terms of the option are for all cash consideration and no unsecured promissory note is involved, it must be sold or assigned, because the new holder exercised the option within the 60 days period, before July 30, and purchased the property with 30 days of the exercise date, before August 30, the option is valid. Question 4. Other than non-dischargeable debts of a bankrupt debtor are cut off, discharged. A. Publication of the notice of the petition in bankruptcy. B. Discharge in bankruptcy. C. The first meeting of creditors. D. Filing the petition in bankruptcy. Answer. B. Debts are cut off, discharged, the date bankruptcy court issues a discharge. Question 5. In which of the following ways may an agency relationship not be created? A. Verbal authority. B. Necessity or emergency. C. Post hoc ratification. D. Subordination. Answer. D. Subordination means lie, trickery or deceit, hence, it cannot be a valid way to create an agency. Question 6. A person and his property that is encumbered by a first deed of trust are in Chapter 7 bankruptcy. The court can sell the property and use the proceeds therefrom to pay debts owed to unsecured creditors. B. Holder of the first deed can foreclose. C. Debtor need not make payment on the promissory note secured by the first deed of trust. D. Debtor can sell the property. Answer. A Chapter 7 bankruptcy petition creates an automatic stay of a creditor's foreclosure against the debtor. Creditor must file a petition with the bankruptcy court seeking relief from the automatic stay and approval to institute foreclosure action. If the note is oversecured by collateral, the bankruptcy court trustee may sell the property, pay the secured creditor, and use the excess proceeds to pay unsecured creditors. If the debtor does not make payments on the note during the automatic stay, the bankruptcy trustee will pay interest to the secured creditor from the date of petition to the date of sale. Question 7. A loan that is secured on easy terms and with a low down payment usually results in A. Increased financing costs. B. Decreased financing costs. C. No difference in financing costs. D. Faster amortization. Answer. A. The lender is not going to be given easy terms or long-term financing without securing something in return. This usually results in increased financing costs. Question 8. Insofar as a residential neighborhood is concerned, which of the following would offer the least protection against blighting influences on future development? A. Natural or artificial barriers. B. Partially built-up neighborhood. C. New neighborhood in the path of directional city growth. D. All families with similar income. Answer. B. A partially built-up neighborhood would have a definite tendency for blighting, because it was not completed and there would be a potential for vandalism. Question 9. In negotiating certain loans, a broker is required to fill in all of the items on a broker's loan statement form. The following item must be inserted. A. What the borrower intends to do with the proceeds of the loan, less expenses. B. A statement of the value of the property supported by a proper appraisal. C. The date on which the borrower acquired the property. D. The amount that will be charged by a qualified agency to render a report on the financial capacity of the borrower. Answer. D. The loan broker law requires, among other things, that the broker's loan statement contain estimated costs including appraisal, escrow, title, notary, recording and credit investigation. Question 10. Which of the following is not a characteristic of an easement? A. It is an interest which can be protected against interference by third persons.
B. S pause. Second equals 0.80 pause. It is capable of being created by a conveyance.
C. It is considered a non-possessory interest. D. It is an interest that can be terminated at will by the possessor of the land. Answer. D. The possessor of the land is the owner of the land. He cannot terminate the easement at will.
Exam Scholar, Real Estate Edition.